Now, is there any chance that the court's proceedings will be televised anytime in the near future?
You probably have heard my dear colleague, Justice David Souter, his remark about that. He said, there will be television of our hearings over my dead body. Now, he spoke with some experience because he had been on the New Hampshire Supreme Court for some years. They did televise proceedings. He had the sense that some of the advocates were acting up for the camera, but more than that, what bothered him was that he was censoring his own questions. Something that would be understood in a conversation between lawyers and judges might be misunderstood by the public. But for me, the principal reason to resist television is it gives altogether the wrong impression of what appellate advocacy is. If you televise a trial, everything is going on right in front of your eyes. But an appeal is weighted much more on the writing side. I always start with reading the opinions that were rendered by the trial court, the Court of Appeals. I do that before I turn to any lawyer's brief. We have what's called a hot bench. That is, judges who have read the opinions below, who have read the precedent and point, the lawyer's briefs, the umpteen briefs filed by friends of the court. So justices don't come on the bench with an empty mind. It's not entirely closed either, but you're bound to be leaning in one direction or another, having done all that reading. So it's giving a false impression that the appellate argument is like a debate and the better debater will win. It's just not so.